Good morning, this is Earl White. This week's video is about 5 legal considerations when buying a fix and flip in New Jersey. We're going to go over what are 5 key considerations to be aware of and how to approach them from a contract and deal perspective, as you're working on a fix and flip in New Jersey. If you found this video helpful, please give it a share with anyone that you think it would be helpful for to review as well. Okay, so first is to be careful with added assessments. An added assessment is essentially when a party, particularly a seller, makes improvements at a property. So maybe they added, anything, particularly anything permitted. So any, notable improvements to the property that are done before the closing when the new buyer takes ownership that have not yet been factored into the property value by the city, which is very common. Obviously, if you've been doing renovations for the last 2 or 3 months, it is not yet going to be factored in to the property value. So at the end of the year, most likely, the city is then going to look back retroactively to probably before the closing and say the property value had been increased before the closing, and therefore taxes are now owed, even though those periods of payment have passed, for that period from before the closing. And now the new owner has to pay taxes. The issue there is that the new owner didn't own the property when for the period those taxes are due. So if it's your buyer client, they're going to call me, call realtors, call whoever, being concerned or frustrated that, hey, I got this tax bill for a period I don't own it. Why am I going to have to pay these taxes? Because obviously they'll become a lien on the property. So how do you mitigate the risk with that? During attorney review, and I very rarely see this added in, on some percentage, but I always make sure to add it in. You want to add a provision that says in the event there is this added assessment after the closing, the seller will then pay the buyer back for the taxes during their period of ownership. So I had a client call me last week with $3,000 or $4,000, from before the closing, but we had the attorney review provision in there, and so the seller, pointed it out. The seller came back, said, "Look, I agreed to it," and paid the money to my client. If that provision had not been there, then the seller probably, they may have done it out of the goodness of their heart, but there would have been no legal hook to make them pay it. Another consideration is bulk sales. What bulk sales is a New Jersey law that says that after a buyer closes on a property in certain circumstances, they would then inherit any tax liabilities the seller had on the property. Now, this is applicable if you're buying from an LLC. Now, we're talking about fix and flips here, right? So fix and flips, oftentimes it's house flipper. They're an LLC, they're a corporation of some kind, and bulk sales will apply. Now, so obviously what you do as the attorney is you submit a bulk sales filing, and it takes, and basically you submit this filing to the state of New Jersey, and then within 10 business days, the state of New Jersey comes back and says, there's no tax liabilities owed, or there are tax liabilities owed. But either way, once that bulk sales is submitted, the buyer no longer has this liability to take it on just because they made the submission. Now, a couple of red flags here that you pay attention to, particularly in attorney review, to protect the buyer, is one, a lot of times the seller's attorney will say, so bulk sales, it applies to if there's an LLC selling the property. There's an exception where it would not apply if that LLC is acting in their ordinary course of business. So the idea being that the state of New Jersey doesn't want to get bulk sales filings every time if an LLC is doing 50, 60 deals a year, they don't want to keep getting filings. So there's an exception for this, for an LLC acting in the regular course of business. But I can tell you, a lot of times sellers' attorneys will say, "Oh, it's regular course," just because it's owned by an LLC. Oh, it's regular course of business, and people just go along with this. They just go along with it. But here's the problem: is that just because it's owned by an LLC doesn't mean that that's the regular course of business. And the important distinction to draw here is one important distinction to draw. I think here is that it's not about the principle of the LLC. That if it's their personal regular course of business, it's about the LLC. So if the LLC itself is newly formed, or if the LLC itself is like one of those LLCs with a property address in it, like in the name, this LLC does not have a regular course of business history where you would get the exception for this. So now the reason it becomes particularly relevant is you need the seller to submit this filing that will absolve the buyer of liability. You need the seller to give the federal tax ID number and other business address and other information to submit the filing. And a lot of times the seller LLCs, they're like, oh, I don't need to do this, regular course of business, I don't want to comply, because they don't want to take the risk that the submission to the state is going to find a new tax liability for them, and then they have to deal with that before the closing. So what you do here, is what I always do, is that in the attorney review rider, and it does come up sometimes, but a lot of attorneys won't do this, you put a provision in there requiring the seller to comply with bulk sales. And a lot of times I still, even though I have that in there, they agree to it, and I still go collect the information after the closing, and they're like, oh, we're not doing it, we're not going to give it to you. I'm like, oh no, you are going to give it to us, because it's in the attorney review rider, so you are going to give it to us. And then usually they'll back down and say, okay, we'll give it to you now. But it's important to have it covered in attorney review, because I have seen this blow up for colleagues, after the closing, where the other side's like, we're not complying or giving you tax ID information because, we're regular course of business. So get it in the attorney review rider that they're going to have to comply with it. Now, obviously, you don't need to do this if it's Lennar, Pulte, if you're buying in a development, if it's one of those type of companies, then obviously it's a relocation company, then obviously it's a regular course of business. You don't need to create a problem about bulk sales. But if it's just this random LLC and there's no history, and particularly if it's got the name of the house in it, then the name of the address, that's obviously this is a single purpose entity that essentially is liquidating. This is not a regular course. This is a liquidation of their only asset. So bulk sales, that's exactly what bulk sales is intended to apply to, liquidation. And so, yeah, you want to make sure you get that covered in attorney review. Buying fix and flip, like we mentioned, often owned by an LLC. And so when LLCs also acquire these properties and fix and flip them, they often were distressed properties prior, right? And they were in distress. And when you have these history of distressed properties, there tends to be ownership and title problems, particularly because sometimes they became distressed because maybe it was a probate or a foreclosure or a tax foreclosure, or a mortgage foreclosure, a tax foreclosure. Maybe it became distressed because it was just getting passed around from family member. So the point I want to make here is that these fix and flips were often distressed properties. Distressed properties were often had title issues relating to the reason they became so distressed, ownership transfers again. So what you can do there to mitigate the risk is to really have a proactive attorney that's going to kind of try to order a title search right away, have a proactive title company that's going to get you a title search pretty quick back, because then if these title issues come up, at least you can start getting them resolved in advance of the closing, so you don't have any long delays. Or if it can't be resolved, then if the deal's going to fall through because these title issues can't be resolved, then at least that will happen sooner rather than later with a proactive attorney and title company. Next thing I want to point out, fix and flips, right? So just because it looks beautiful doesn't mean that everything is all the proper legal channels have been followed, in particularly relating to either having open permits or having failed to obtain permits for work that was conducted. I've seen them, a lot of times where even if you ask the seller up front, hey, were there any open permits? I'm like, oh, no open permits, no open permits. But then we get the deal moving, and then we find out about there's a ton of open permits, or there were some improvements that were made that should have had permits but didn't. So what you can do to mitigate the risk on that one is just when you get out of attorney review, have the attorney or someone to submit an Open Public Records Act request to get the permit history. And then this way, in this way you can have someone take care of these permitting issues, early in the deal, so you don't have a delay down the road. And this comes legally or to the buyer, very important. If the city does not have some kind of CO requirement, like if there's no one from the city is going to go prior to the closing to check if there's work without permits, or check the city record, which is some cities, they don't have any requirements like that. It's really going to come down to the attorney working on the deal to identify this problem, or the realtor working on the deal to identify the problem, or I guess the buyer could do it, but most buyers, they might not be aware of all these things. So it's going to come down to the attorney's working on it to proactively resolve it. And to that extent, you also have to make sure the attorney review rider covers it. Inspection contingency is not enough. Inspection contingency says if there's defects at the property, then the buyer can raise those and the seller has to either remediate them or the buyer can walk away. That's standard. What's not always included and not always standard is what's going to happen when everything is done, all the work looks beautiful, all the work was done properly from a physical defect perspective, but all the legal channels and the permitting weren't obtained. And so that can get a little bit dicey, right? So, and there could be some, there could be some disagreement. So what you want to have is an attorney review provision that tackles open permits, open code violations, or also work that doesn't have any open issues, but just they didn't get the proper channels because it's not clearly an inspection issue. So you need that covered separately. Next thing I want to point out is signing authority. If you're buying a fix and flip, you're very good chance you're buying from an LLC, as we kind of mentioned. So with the LLCs, sometimes the properties will change hands, for perfectly legitimate reasons. But you want to make sure whoever signed the contract had authority to do so. And sometimes you'll learn that that's not the case. Someone signed off and they may not have had authority to do it. So normally what I would do is an attorney review, add a provision to the rider, something along the lines of, within 7, you don't want to hold up attorney review for this because it's a low probability event, but something like within 7 days of concluding attorney review, the seller to provide documentation showing that they were, authorized signers on behalf of the seller and, can complete the sale. And that usually means getting the operating agreement from, the company, the LLC, and then also like a certificate of good standing and a certificate of registration. If there is no operating agreement that's been signed, then really it just comes down to having the certificate of registration showing who the members are, and then making sure all those members sign the contract, so you don't have any disputes down the road about whether it's a legally binding contract, and that all gets resolved early in the deal, rather than having a problem after all the work has been done on the deal before the closing. Okay guys, like I said, if this video was helpful, feel free to share it or give it a like. Thank you.